All right. Shh. Welcome back. Welcome back. All right. How's everyone doing? Good. I don't know, put the clock there, but it's a bad idea. You never want a clock behind you because all you're looking at is the clock. In fact, at the Supreme Court, if you ever go, there's a clock all the way at the top. It's really high up, and there's actually a rule in the court instruction book saying, "Do not look at the clock." It's in the book. Do not look at the clock. You have a little, at the lecture, you have a little light flashes when you have time left, right? So never, ever have a clock behind you because that's all you're looking at. One year I was teaching at Penn State Law School, and they were in the tournament, and the tournament was on while I was in class, okay? So everyone was watching ESPN and 3 at the time, right? So I was like, okay, let me try something. So I actually put the game cast behind me. Thinking, all right, at least their eyes will be facing me rather than yes. So mixed success. So every single person, because they had an AT&T on their internet, they were watching ESPN3, they were watching the game, and no one was paying attention to me. And then the game, the game finished. Wherever you want, yeah, go for it. Everyone know Professor Maxine Goodman? Say hi. If you have for legal writing, you're very lucky.
I will not be coming in and teaching you ConLaw. That would be very bad.
Oh, I love that.
Very bad.
Welcome. See you, Maxine. Okay, let's see. So any questions, anything on your mind, anything lingering, anything dwelling, anything bothering you? All right, everyone settle down? Anything in your minds, anything? No? Okay, let's get started then. So our last class we were discussing, our last several classes, we were discussing Equal Protection Clause, okay? And let's do a little bit of review so we get a gist of where we were. So the 14th Amendment by itself is fairly straightforward. You can read it, in a few minutes. It doesn't take you very long to read. And it provides certain protections against state action. And the one we focus most on is equal protection. And it says that the state cannot deny to any person within its jurisdictions the equal protection of the laws. So that language on its face doesn't really give you much, right? It doesn't really tell you how this law should be applied. So the Supreme Court's developed a doctrine that we discussed. Swift, right? You have these different tiers of scrutiny which are used to determine how closely a court inspects a law, okay? So I'm going to go fairly quickly here because we've already done this, but if you have any questions, stop me, okay? So we discussed that there are certain suspect classes: race, religion, nationality. And the court has said that when the government makes a classification on one of these suspect classes, segregated train cars, segregated schools, bans on Catholic schools, you can think of a few examples. These laws are inherently suspect. And even if the government has some sort of reason why they're doing this, to keep the racists safe and to, prevent violence and whatever other justifications for segregation exist, the court will scrutinize it strictly, okay? And this is where we get the phrase strict scrutiny. The court didn't actually make up this phrase, although it's become so commonly used that that's more or less how we call it, strict scrutiny. And again, we have this relationship between means and ends. And I want you to actually understand the means and ends. I don't want you just to memorize the test, because everyone's going to memorize the test and spit it out in the exam and not know what the heck it means. Okay, so let's actually digest this. The government has some sort of goal. I'll use Korematsu as the example because it's easy. The goal is national security, right? Keep our coast safe from the Japanese. Okay, how do we get there? What are the means? Well, the government says the only means we can use to get there are by rounding these people up and throwing them in concentration camps. That's it. Now, we said that the outcome in Korematsu was terribly wrong. So were we to actually look at this case, honestly, we say, wait a minute. Okay, we'll give you your end of national security, right? That's legitimate. We're not going to question that. But couldn't you get there in, a least burdensome way or a more narrowly tailored way, maybe by saying, well, give these people a loyalty oath, or see if they have any connection to Japan, or do a background check. I don't know. There's 100 different ways you could achieve this in a less, burdensome way, right? It's in the news, but generally government, when they infringe rights, must do so in a way not to burden people too much. So we say, right, is a classification narrowly tailored to serve a compelling governmental interest, right? This is the standard restatement of this test. You might see it phrased slightly differently, but this is the general gist, right? Is a classification narrowly tailored, right? These are the means. How are you going about achieving this goal? Okay, we have an order saying if anyone with Japanese ancestry got to go on the buses and go to camp. Okay, I'm being sarcastic on purpose, in case you couldn't tell. What are the goals? What are the ends? Well, here it's national security, right? You have to promote national security. So whenever we have any classification that's suspect, one of these suspect classes, race, religion, or neutrality, that triggers the inquiry under strict scrutiny. Okay, so let's use the other example we did, the affirmative action case. Okay, we did the Michigan affirmative action case a couple of days ago. Okay, so what is the goal? The goal is, the court said, the benefits that flow from diversity. That is the compelling governmental interest, that the benefits from diversity are so important, this rises to the highest level. And when I say compelling, I mean it's really high. This is not just some sort of middling, it'd be nice if we have it. This is like essential stuff, okay? What are the means being used to achieve that goal? Well, the court said one worked, one didn't. The mechanical quota, where you just add plus 20 points, whatever it is for race, that was a no-go, right? That was not narrowly tailored enough because it made too much use of race. Okay, but the law school, you recall, did something a little bit different. They had this holistic approach where they looked at race and looked at this and looked at that, and this, smorgasbord, potpourri, melting pot, whatever you want to call it. That was fine. That was narrowly tailored enough. It didn't, Goldilocks, right? Not too much race, not enough race, just the right amount of race to satisfy the terms of scrutiny. Okay, so everyone get that? Any questions about it? You should be able to recite these 4 lines in your sleep. And I mean that sincerely. You should be able to say, oh, wow, racial classification, that means strict scrutiny, that means narrowly tailored to compelling governmental interests. You need that cold, right? I don't mean memorize. You need to understand why it applies. Most people just recite this, have no idea what it means. You actually know what it means. Job?
Do we have any sort of, boundaries on what governmental interests are?
Oh, okay. So if you read Justice Thomas's dissent in the Michigan case, he basically says this is a crock, right? Compelling interest means like national security. It doesn't mean the benefits from diversity and education. Justice Thomas was in dissent. So there's a vigorous debate on the court over what rises to this level of compelling. If you read the Michigan case, a lot of stuff's out, like, having, compensating for past people, minorities in positions of leadership. That's not an interest, right? The only interest they accepted was diversity and education. So I don't want to put too fine a point on this, but there are basically 2 compelling governmental interests in American history that have worked. There are 2. National security during World War II and the benefits and diversity at the University of Michigan. That's it. So the answer to Job's question may not be very satisfying, but the general gist is it's got to be really high. And I would dare say the Michigan case is maybe a case by itself, fit into the rubric of that. But if you want to believe that, I think that might be a reasonable thought. All right, other questions on strict scrutiny. And yeah, again, you got get this one cold. Recite this sentence 30 times and just be able to understand what it means, because you'll be much better off when you have to write for the exam. Yes, ma'am.
So, Black, can you repeat? So, compelling national interest would be national security and
the benefits flowing from diversity. And I don't mean to put that too glibly, but the court had to they already had this compelling interest test, and they kind of fit diversity into it. And as a matter of logic, it doesn't exactly fit in the same way as, you know, World War II, but still held Justice O'Connor. Thus spoke Sandra. Anyway, what else? A couple people got that one. And soon thus will speak Tony, as they say. Tony will ride the pony. That's actually the Clark's name. When Tony rides the pony, that's when Kenny's on his own. Anthony Kennedy. Tony rides the pony. Anyway. So any other questions on strict scrutiny? You have no idea what you're getting yourself into. I'm sorry. Our friend is from high school, so I'm sorry. Oh, don't worry. This is atypical, I promise. Okay, so everyone go with strict? Okay, so now we go on to what are called quasi-suspect classes, which is basically just gender and legitimacy. By legitimacy, I don't want to be mean to anyone, but it's a child without married parents. And today that doesn't even mean anything at all. But at one point, being the child of unmarried people meant you were illegitimate, or to use the slur, a bastard, right? Today, this has absolutely no relevance. But believe it or not, at some point in states, if you were an illegitimate child, you could not inherit property. There were actually laws punishing people who were born of unmarried parents. How far we've come in 30 years, I suppose, right? So we'll just focus on gender to make this easier, right? Until the 1970s, gender was basically considered a not a suspect class. By the 1970s, we had this new thing called intermediate scrutiny, right? Again, it's not quite strict. It's not quite, you know, the bottom rational basis. It's somewhere in the middle, closer to strict scrutiny. And the government says, well, you know, when there's a classification being made on the basis of gender, you know, we should be suspicious, right? We should be suspicious. Not quite as suspicious as race, but, you know, suspicious, right? Why is the government treating people differently? So let's use the beer case, right? The Craig v. Boren case. You know, why is it that girls can buy beer at 18 and the boys have to be 21 to buy the beer, right? And the court said, well, this is based on stereotypes that girls are more responsible than boys, also the garbage. So this is a unlawful classification. Okay. But then we come to our favorite example, which we go over and over again, which is the bathroom, right? The state has a public pool, and they have a men's locker room and a women's locker room, right? Is this a classification based on gender? Absolutely. Is this classification based on some sort of negative stereotypes about women, or maybe based on views of inequality of the genders? Maybe women are too quaint and they can't be around men who are naked. I don't know. I mean, there are certainly those that exist, but the mere fact that there's a classification based on gender doesn't render it void. 1 second, Jason. Right? So with strict scrutiny, it's often said strict in theory, fatal in fact. The government has a burden it cannot carry. What do I mean by that? With strict scrutiny, basically, the government's burden is so big, it's not going to be able to ever meet it. They'll never be able to prove it, except for affirmative action and detention, apparently. Okay? In contrast, right, the gender scrutiny is a much more forgiving standard. It allows the government to try to make laws. So you ask this question, right? Is the classification substantially related to an important governmental interest? And again, here are our means, substantial relation, and here's our ends, right? Important governmental interest.
Let's also
look at the beer case, right?
What is the government's interest? Well,
They don't want underage drinking. They don't want traffic accidents. All this other stuff, right? That's their end. What is their means? Well, their means is a classification that allows 18-year-old women to buy the beer and only 21-year-old men to buy the beer. Okay. The court asked, is that classification tailored enough? Like, is it narrow enough? Does it actually reflect the fact that the government's trying to make this classification without unduly burdening the sexes? And the court said, no. Same for the VMI case, the Virginia Military Institute case, right? What's their end? Well, their end is to make citizen soldiers and like, these Rambo characters, right? And what's their means? Well, to exclude women altogether. What did the court hold? This was not narrowly tailored enough, right? They could accomplish the goal of making these, super soldiers, with admitting girls. Okay. What's noteworthy here is that the government also has the burden, but it's a smaller burden. In other words, I keep coming back to the swimming pool example because it's the easiest one for people to relate to. But if someone filed a lawsuit saying, you know what, I'm a man and I was denied access to a locker room in a public pool, the women's locker room. He brings a lawsuit claiming gender discrimination. The government lawyer would come and say, wait a minute, look, this is not based on any kind of racism, sexism, or discrimination. We don't want the genders to be together in a bathroom because we think it might have some sort of public safety implications. Maybe and again, it's based on stereotypes. We don't think men can control themselves around women, or we don't think women can handle having men ogle at them. I don't know, whatever the rationale is, right? Maybe some people think that's a stupid rationale, but it's probably enough to carry the day under this form of strict scrutiny. Now, if the exact same issue was segregating based on the race, you're saying, well, we have a black locker room, we have a white locker room, right? White people getting together, they'll start fighting, right? The exact same rationale as applied to race would fail. But as applied to gender, yeah, I mean, maybe you don't like it, maybe you do, but that's why I think the court settled on this intermediate framework, right? They recognized that there might be some inherent aspects of men and women that warrant differential treatment. Again, not everyone agrees with this, right? Some people may say this gender gets strict scrutiny, and any classification on the basis of gender should be invalidated automatically. Okay, Jason, your hand was up. Sorry to cut you off.
Something that's always bothered me, for example, like last week we touched on like the girl football players,
Mm-hmm.
and you see this happening more in like high school football, where girls come on, or like kickers, or play other positions. But if a guy wanted to go play women's volleyball, they wouldn't allow him to do so. Or women's softball, they wouldn't allow him to do so.
I mean, so I mean, the issue with sports is an interesting one, right? Because in public sports, you have something called Title IX, which requires the equal payment of a fund. I mean, supposed to be at least equal payment of funds to both men and women athletics. It doesn't always work like that because I'm sure the UT football program gets a lot more than say the women's, I don't know, tennis team. Picking a random team, but on the aggregate, it probably balances out somewhere in the books. But we actually have a lot of situations where people who have a gender reassignment, sex changes, right? And they now identify differently. And they say, okay, I used to be a man, now I identify as a woman. Okay, let me on to the women's Olympic team. And there are actually legitimate debates over that about whether that's actually appropriate. And the argument, which I think Jason is alluding to, is that they may still have the characteristics, the athletic characteristics of a man, and it would not be fair, right? Some may agree with this, some may not agree, but these are live issues that we have to deal with. Okay, yes.
So will this move gender at some point from causes suspects up to strict scrutiny?
Will what move?
Well, this gender.
What's this?
The idea that transgenders are having more rights. I mean, that is a problem.
So preview now for the same-sex marriage cases, right? And one of the big issues with the same-sex marriage case is how will the court resolve this question, right? I'll put this in writing. They're gonna rule for gay marriage. I don't think that's an issue, right? What's interesting to me is how they get there. Okay, do they find that bans on same-sex marriage are a form of discrimination on the basis of sexual orientation, right? Discriminating against gays and lesbians. Well, at the moment, they're not even a suspect class. They're not even just as rational. It's at the bottom. If the court holds that sexual orientation becomes a suspect class, that puts women in an awkward position, right? Because women are in the middle, in this intermediate, And then gays and lesbians are now at the pinnacle. And effectively, that would say that there's absolutely no law that could take consideration of any person's sexual orientation, which would invalidate a lot of laws. Okay. You mentioned transgender as a protected status, right? If that's given strict scrutiny, then yes, if a person who previously identified as male now says I'm female, he would be allowed to enter a female locker room. And this is not an academic question. There was actually a story, I think at a Planet Fitness, where it was about a month ago, where a woman was in a locker room showering or whatever, and she saw some person who she deemed to be a male. He did not agree, and she complained, and the person who complained was actually had her membership terminated for discrimination because the gym could not expel someone who identified as a female. Similarly, Title VII of the Civil Rights Act of 1964, which is the major discrimination law, right? It has a provision later added for gender discrimination, right? You can't discriminate in place of public accommodation based on gender. For the last 40 years, the law was silent with respect to transgender people. About 2 months ago, the Department of Justice took the position that Title VII now covers people who are transgender. And they actually just filed a lawsuit in Oklahoma for a professor who was denied a tenure because of, the professor claims it was because he was a transgender, right? These are live issues, and I don't mean to give you any answers. I don't have the answers, but these issues are live, and the extent to which we want to shift everything into high gear with strict scrutiny means that society won't be able to make any laws that protect certain social mores or protect certain aspects of the police power. We'll be discussing later with Lochner, right? Every single time you say, oh yeah, strict scrutiny or a suspect class, you've just imploded a chunk of the police power. You've also afforded to some people a level of protection that they did not previously enjoy. So these are really difficult decisions to be made. And when we'll discuss the same-sex marriage case, I'll probably come back to this, because I know right now Tony's on his pony, but he's got to answer this question, right? He was able to slop off this question in the past, but at this point he needs to hit it like head on, right in the forehead. No one got that. Head on. Okay. Probably directly to the forehead. Remember that? No, Google it. All right, what else? What else is on your mind? Yes, Connie.
Okay, like if you were going to take the military school, and I know this is controversial, but if they wanted to take that same argument about BMI and they wanted to put the ends to be national security, then could they have kept women out? They framed it. Or is it
I think
like, is it,
you know, honestly,
honestly,
I think that argument would be very attenuated. I mean, the school itself wasn't sending people to the military. It was preparing people who could apply to the military academy and be enlisted or commission officers. So I think that argument would be a little bit of a stretch.
well,
Not anyone can assert national security. You'd actually have to have the government asserting that argument, like the United States federal government. Virginia doesn't have much of an interest there. The party to assert the national security argument would be the United States federal government. You know, Virginia can't. They have no role in national security. And in fact, in this case, the Department of Justice opposed the school. The federal government said, no, this is not necessary. And in fact, West Point, Air Force Academy, others, they admit women. So that argument probably wouldn't go very far. Any other questions? Yes, sir. Yes, you.
I had a question about do they apply to laws that suit a certain class but don't discriminate against them to try to give them benefits?
Ooh.
Yeah.
Well, so Plowman's question is a good one, right? What about laws that benefit people?
Inside our class.
Well, wasn't that the affirmative action programs?
Right. That's what I'm.
What weren't certain minority students benefited by this program? Who brought the case? Who filed the case? A white girl. A white person filed the case, right? Who got the benefit in BMI? Who was able to go to school? No. Who was able to go to school? Who's admitted to VMI initially? Who filed the lawsuit challenging this? A woman, right? In the beer case in Oklahoma, who was allowed to buy beer as a younger person? Who filed the suit? Right. So anytime, and this is Plowman's question, good one, right? Anytime one class gets a benefit, by definition, the other class is worse off, right? Anytime that men are admitted to that school, women are not admitted. When women can buy beer younger, men cannot buy the beer, right? When a minority is admitted to the school, the white person is not admitted to the school. So it's two sides of the same coin, right? By taking a load off one side, you're putting the load back on the other side. Whether that's good or bad, it's a question of scrutiny, right? But merely conferring benefits to one side means you're disadvantaging a different side, or so the argument goes. Questions? Everyone okay with intermediate scrutiny? Okay. So now we go down. We go down our list to non-suspect classes. And we put in parentheses everything else, okay? And I don't mean that to be a shorthand. Anything that's not race, religion, or nationality for strict, or anything that's not gender or legitimacy, is a classification based on something else. And we say that this is afforded rational basis review. Okay? And every time the court invalidates a law based on one of these tiers of scrutiny, they are taking a chunk out of the state police power. They're telling the state, you can't do this and you can't do that. Even if you think this is going to help your people, you can't do this, right? It's removing a sense of sovereignty and autonomy from the people through their elected branches. Rational basis reflects the opposite, saying, well, you know what? If you're classifying people based on, age, I'll keep using age as the example, right? It's an easy one. Age, for example, right? If you're saying that 17-year-olds can have licenses, but 16-year-olds can't, that is a legitimate judgment to make as a member of your government. You can decide that, 16-year-olds are responsible, but 17-year-olds are not. Is that always going to be true? Of course not, right? I'm sure, I don't know how old you are, but I'm sure you know that there's some 16-year-olds who are very immature and some who are very mature. And then you have a bunch of idiot 17-year-olds who are, going around drinking beer and being idiots, right? But because this is not a suspicious classification, because we don't have a history of age discrimination in the same way we have a history of gender discrimination or race discrimination, this is going to be okay in almost every single case. So we ask ourselves, right? Is the classification rationally related to a legitimate, I can't type today, sorry, to a legitimate governmental interest? Is a classification rationally related to a legitimate governmental interest? So again, we have our means and we have our ends. Okay? If you notice at each tier of scrutiny, it gets a lot less strict, and I don't mean that lightly, right? Each tier, it gets easier for the law to survive. So what's our ends here? Does that have to be compelling? No. Does that have to be even important? No. It has to be legitimate, right? What's legitimate? That means, not terribly wrong, right? Like something like an illegitimate means to be like trying to punish people, trying to hurt people. If you say, safety, that's probably good enough. If you say, we're doing this for safety, legitimate. It's not national security or even, to avoid gender discrimination. It's, yeah, whatever, I'll make us safer. No big deal. And what are the means used to get there? Are they rationally related? In other words, in someone's mind, can you connect point A and point B, right? In someone's mind, can you connect a 17-year-old driving age to public safety? The answer is yes, right? Do you need statistical evidence? No. Do you need witness testimony and hearings and elaborate reports showing that on average 16-year-olds have this level of accidents and 17-year-olds have this level of accidents? Of course not. Just saying, this is rational. Does it make sense, right? Could someone, somewhere, in some state legislature imagine that putting a 17-year-old driving age was a good way to accomplish public safety? The answer to that question is yes, the law survives. Okay? So what happens here, and you can write this very clearly, is the government almost always wins. I'll put almost in parentheses, because there are very few cases where rational basis results in the invalidation of a law. Yeah.
So rational basis, like for example, the Texas legislature, the Texas House just voted on a measure to ban texting statewide while driving.
Yeah.
Do you think rational basis?
What's the classification between people who text and people who don't? Yeah. Can the government separate people who text behind the wheel and people who don't? Is that rationally related to public safety? Yeah, the law's fine. And you see why, right? You're basically separating people who text and those who don't. I mean, that's an easy case. I mean, that's really easy. No one, texting is not a suspect class quite yet, although if you see those idiots with the selfie poles in front of burning buildings, they may be suspect in a very different way. Google it, New York Post headline. So, with rational basis, the government almost always wins. In virtually every single case, the government's going to win. I was actually at Yellowstone Park last summer, and there was some moron standing on the edge of a cliff with a freaking selfie pole. I want to nominate her for a Darwin Award. I mean, oh God, not worth it. Okay. But the important part is the government has no burden. The plaintiff, challenger, has the burden. The effect of that is the government is under no obligation to actually defend their laws. I use this example as a joke, but it's serious. It's like, you know, you walk into court, you're a government lawyer, say, Your Honor, may it please the court, the state rests. You'll win, right? The burden is entirely on the challenger, right? To as I say, to negative every conceivable rationale. In other words, every possible reason why the government could act, you have to negative. And why this is impossible is a moving target. Because the government can basically make stuff up. They can make up, oh, maybe we have this rationale, maybe we have this rationale. Does any of that be in the record? No. Even one step worse, right? The government can make stuff up, so can the courts. The courts, after you've submitted your arguments, right, the case is submitted, you've submitted your briefs, it's done. The court can then make reasons up why this law is valid. You have no chance to rebut them. This is often like a Don Quixote style thing. You're tilting at windmills, right? You're never going to hit your target, and you're not going to win. It's very quixotic, you might say, right? Good PSAT word. So, generally speaking, once you have an equal protection classification, the government wins. There are very, very limited exceptions, which we'll discuss when we do same-sex marriage. Some of the related cases involving that, but the general rule is the government wins. Okay? So any questions on equal protection and the three scrutiny tiers? I want you to have these cold. You feel to recite these three paragraphs in your sleep, right? And understand why. This is one of the few tests I'm going to give you that I'm actually going to ask you to memorize. Most stuff, no. But this stuff, you need to have cold down pat. Yes, Connie?
I have a question, like, okay, this last section, like, the rules in New York, like, you can't get these huge sodas. Would that fall under there?
So the issue with New York is not one of equal protection, right? They're not really classifying people based on soda. What they're actually doing is perhaps infringing on a liberty interest to drink whatever the hell you want.
But it's
But
quite
they could
safe.
One at a time,
sway it
one
that
at a time.
way. They could sway it that way. They could say, well, we're trying to make our citizens healthy or whatever.
Well, if they're
Frame it
saying
that
it's an
way.
equal protection issue, it's rational basis review and the law survives.
That's what I'm-
Right. That's why the state has a very broad police power to regulate health, safety, and welfare. We'll do this when we do Lochner in a few minutes. In fact, it's a New York case. The interesting thing with the soda ban is it's really infringing on what you can do in a way that some people may not like.
It seems like that's a slippery slope. I mean, you can
Well,
say whatever.
Lochner, we'll do Lochner in a few minutes, and Lochner was the slipperiest of slopes we have. It's like Aspen. It's really slippery. Jason?
She made a point. I was just saying that the public health interest.
Right. Okay. Other questions? Okay, so we're done now with the equal protection. That's it. Okay? What's going to make you happy and make you confused at the same time is that the 3 tiers we discussed for equal protection translate to the due process clause. That'll make you happy. What will drive you nuts is that there are 3 totally different tests. Of course, the Supreme Court makes us mad, right? So the stuff about compelling interests and rationally related, right? Those are the tests for equal protection. I want to make this really clear. Do not confuse equal protection and due process. Do not confuse equal protection with due process. Justice Kennedy does it all the time. It drives me nuts. I expect better of you. Okay? It's true. You'll see what I mean in about 2 weeks. We are now talking not about equal protection, but due process of law. Okay? We have the 14th Amendment, right? Was it page, was it 48? If I have memorized it at this point. Wow. Okay. Page 48, right? Read it. Real simple. Nor shall any state deprive any person of life, liberty, or property without due process of law. Where did I finish last time? Start moving around. Who are you pointing to? Oh man, you threw her under the bus. Wow. All right, Sarah. It's okay. It's okay. It's like, thanks. Sarah, okay, you're up first. Okay, I'll give you an easy one, right? Because you just got to round it out. Okay. Sarah, no, it's okay. I appreciate it. So, Sarah, everyone, shh. Okay. So, Sarah, just reading this one sentence, right? How would you, without knowing any history, just looking at it plain, understand this provision of the 14th Amendment to operate? What would you understand that it does? Good. So what does due process mean? Again, just looking at just the text, don't bring any history or anything else you know. Okay, of the court. Okay, good. Good. What do you think, Demi? When you see this phrase, due process of law, these words, right? What do those words mean to you? Just looking at it plain.
I was kind of agreeing with Sarah of the court, because one of the things that we did is, the statute recognizes him specifically that can say the sheriff can take all their property. So I thought that,
Using example from the book, huh?
well, I was saying I agree with that. I didn't want that was of the court, and they had this go through the procedure like.
Okay, let's break this down, right? Haley, just 2 words, due process. What does that mean?
So like in a literal sense, you do it in code,
Okay.
and process is the procedure.
Good, right. So I think we can say, this one's easy. Due process means the process you're due. Never thought of that way, did you? But that's an easy one, right? Due process is a process that you're due or owed, to use the word that Haley used, right? What process are you owed, right? Who determines what process you're owed? And who determines that? Sam? It's right there in the sentence. Who determines what process you're owed? Doesn't say state. Who determines what process you're owed? Due process of law. Law. This is the important part. Who determines what process you're due? Not some arbitrary king or some mean sheriff, but law that is established, right? There is law that is fixed. There is law that everyone is subject to. No one is above this law. So there was a Roman emperor, I think it was Caligula, who would often write laws, right? But he would put them on top of these really tall columns so that no one can read them, right? No one can even see them, right? Ian, was this law? I mean, he wrote, I mean, I guess you shimmy up the column, right? But he would put these things on these really tall columns. Is that law? Ah, so I think what you're saying is, in order for something to be law, it has to be known, right? I think that's a fair thing, right? In order for something to be law, people have to be on notice of what is expected of them, right? Putting a law on the top of a column that no one can read, this really high column, that's not law. So this phrase due process of law, which you probably read 1,000 times and never actually thought what it means. The reason why I did this exercise, I remember very distinctly sitting in my first year ConLaw class saying, what the hell is this due process? What does this mean? So now you know, there's history here. This phrase actually traces back 800 years. 800 years to, come on, someone knows. What happened 800 years ago this year? Magna Carta, thank you very much. Magna Carta, it's in the notes too, wasn't a surprise, right? Magna Carta, the 800-year-old Great Charter of Liberty, has a provision, one at a time, has a provision that says, I'm going to paraphrase it, you can't be deprived of your life, liberty, or property, but by the law of the lands. The law of the land. What does this mean, the law of the land? Law of the land is synonymous with due process of law. They mean the same thing. Law of the land, due process of law. It basically means that there is a separate law beyond whatever the king or monarch says. There is a set procedure, a set of rights that exist independent of whatever the whim of the arbitrary government says. That it's not like Caligula with the laws on top of the columns, right? You know in advance what the expectations are. You know this is legal, this is illegal, and if I do this, I'll be fine, and if I do that, I'll be in trouble. If I do this, someone can take me to court and sue, right? The bedrock notion of our due process is one of fairness. You know what the laws are, and they're applied even-handedly, right? This has been the law for, in the, at least the Anglo-American system, for 800 years, right? This is not some sort of thing we just made up, a couple years ago. This is an almost 1,000-year-old tradition which we cherish and value process because process matters. Making exceptions to rules are the act of an arbitrary king, right? Even if you don't agree with the outcomes, the process always matters. Never forget this. And I want to make it clear, right? If I had a choice, because I'm in the Constitution, right? I had a choice. I could either put this beautiful Bill of Rights or structure things in a very procedural way. Here's how laws pass. You have the House, you have the Senate, you have this, you have that. That president vetoes it, right? Tell me that, and I'll know what the government means. Give me a Bill of Rights, fluff. It's the structure and process that defines our government, and don't forget that for a minute. Okay. Okay. So we have this phrase. So if you want to deprive someone of life, their liberty, or property, by the way, people say the death penalty is unconstitutional, have to ignore the 14th Amendment because you can be deprived of your life with due process. Right? It says you can be killed if you're given process. It's right there. So, but I won't dwell on that for very long. Yeah, it's right there. But yeah. I mean, if you want to take a living constitutionalist approach, fine, but it's right there. So the question of what process is due to a death penalty case, maybe a different question, but the death penalty can't be unconstitutional by itself. Okay. So how do we know then, right? So as long as you're given process, let's see, Connor, right? So as long as if the government wants to take away your property, say, or they want to kill you, and they have a fair trial, they can do whatever they want to. Is that right? If they give you your due process of law, right, gave you whatever procedures were necessary before taking away your life or liberty or property. But is that permissible?
I think that would be awful.
It'd be what?
I mean, if they follow like the proper procedures, then I think that would be appropriate.
Okay. So, does anyone know about the story called The Lottery? Anyone ever read this? It's a short story. Don't ruin the ending. Okay, so I'm going to summarize it, but maybe I'll call on you in a minute to answer a question, right? So there's a story, right, called The Lottery, and it takes place in this small town. And it opens up, and everyone's thinking, oh, the lottery's coming up, the lottery's coming up. And everyone starts getting ready for it. So the mayor of the town starts making these paper slips, right? One for each family in town, okay? And one of these slips has a marking on it, okay? And they throw all these slips into a safe, okay? And then at 10 a.m. the next day, each family comes and draws one slip, a blank slip of paper from the safe. Okay, totally random, right? The procedures are very fair. No one can look with, they grab a paper at random. Okay, so then one family, the Hutchinson family, draws a slip of paper with this black spot on it. Okay, so his family, drew the unlucky slot. Okay. So they go back, right? So the second round is that each member of the family draws a piece of paper from a different safe. And there's going to be one piece of paper in that safe that has like a black spot on it, right? And the mother, Tessie, draws this slip of paper, right? And has a black spot on it, okay? So Connor, I'll ask you this question. Is there anything unfair? Is there anything unfair about this procedure? I'm not implying anything. I'm going to call on Brandon in a minute, but I'm not implying anything. Is the procedure, everyone's drawing a random piece of paper, locked down, safe, no one's looking inside, everyone's drawing random. Is that fair? Is that a process? They're following the rules of the city, that this is written in law, that everyone draws a piece of paper. Is there anything unfair about this? Okay. Brandon, what happens after the wife draws the marked piece of paper? Oh, you didn't see that one coming, did you? She's stoned to death. She's stoned to death. And as she's getting stoned, she says, quote, "It isn't fair. It isn't right." These are her last words. Okay? So why don't you ask yourself this, right? Is process by itself consistent with due process? Right? Is having a fair, it wasn't a trial with a jury, but it was a fair procedure. You drew the slip of paper, you drew that. I mean, it was designed perfectly, that there are no objections to how it was drawn. Even if something is done in accordance with the land, can it be unjust? Can it be unfair? Jacob, what do you think? I mean, this procedure with the drawing the papers, everything was kosher, right? There was no problem. Is there any unfairness there? No, she was given process. Absolutely not. She was given a very, very rigorous process. Louder? Where do you get this wrong from? She was given, all it says is process. She was given process. What's the problem? No. You can deprive, this is not circular, right? You can deprive someone of their liberty if you give them process. That's what they said a minute ago. What's the problem here, Christian? We took away her life with process. What's the problem? Ooh, substantive. What's the substantive business you're talking about? Oh man, now you're talking, right? What is this? How can something procedural be substantive? Aren't those opposites? Aren't those antonyms? If you remember your elementary school grammar, how can something that's procedural be substance? It is, and I use this lottery story to illustrate this notion, right? So some people, for example, Justice Scalia says, look, it says due process of law, right? All that means is you get process. There are no substantive rights. There are no issues of, to use Jacob's word, fairness, right? He said fairness, right? Is the word fairness anywhere here? No. Fairness is a judgment we make as a matter of substance. Like, is this fair or not? They filed the letter of the law to a T. They drew the slips of paper exactly as they were supposed to. But there's this notion, which a lottery store, I think, makes very clear, that not every procedure is fair. Not every process of law is just. So the phrase Christian mentioned, substantive due process, takes it one step further. It says, okay, we think that this law is not just. Therefore, as courts, we can find that it's inconsistent with due process of law. So it's not enough for us to sit here and debate as a matter of policy, or in the state house to debate laws, whether a law is just. Substantive due process allows judges to say, we do not think that this law is fair. We do not think this law is consistent with due process of law. Therefore, you're being unlawfully deprived of your liberty interest. This law is void. Right? Even if you're giving all the process in the world, that process is not sufficient to infringe on this liberty interest. Vicky?
I know we're not
Okay, so, and this is a point I was going to make in a few minutes, I'll make it now. If you're classifying on the basis of, race, religion, whatever, right? You go to equal protection. If you're infringing on a right, using an easy one, abortion, birth control, sodomy, list them right down, right? That is not then a classification on the basis of gender, right? That is saying we're infringing your right to access abortion or whatever. So when we're talking about infringing on rights, we talk about due process. When we're talking about classifications, it's a matter of equal protection. At times, these blur. And to use the example, is a ban on abortion violation of right to reproductive rights or gender discrimination? Justice Ginsburg has argued for 30 years that impediments to abortion is actually a form of gender discrimination. Why? Because only women need to get them, right? No other classification gets them. All right? The court has not adopted that rationale, but in your own minds, you may see the two blur. So at least try to keep separate classifications, protection, and then liberty interest, which is due process. Go.
So it's kind of the concept of the political process, the opposite end of the process. Like if you don't want to be stoned to death because of a lottery, change that law.
Oh, so right. So, and one of the interesting aspects, and Brandon read the story, he might say a few words, but everyone in the town was haunted after this, right? Everyone in the town's like, wait a minute. We went through this process and it just doesn't feel right. Brandon, what was your thoughts reading the story?
I mean, it's been a while since high school.
Oh, okay. Well, it's okay. You don't remember.
It's kind of fun because I know, like, the mom was the one who ended up getting stoned to death.
Right.
And like her friends, like, at first everybody was kind of happy that they weren't the ones chosen.
Yes.
Like, even her kids were like celebrating that they weren't the ones.
Isn't that perverse?
A little bit, yeah. But like, a lot of her friends were like, they were like bringing heavier rocks, so like they would kind of be like the last ones to get up there, so they would already be dead by the time they arrived. And there's definitely some ill feelings.
Yes, sir.
Yeah, I agreed too when I was in college, but they had been doing this for years though.
Yep.
So it wasn't like the first time they tried it. So I mean, I don't know.
Yeah.
I don't know if they were like, weirded out by it.
Because next year they'll go back and do it again.
Yeah, it's like a whole thing. Like the kids got to pick the rock they wanted first before the adults did. Like, they do it every year.
Right. So the story is disturbing. If you want to read it, it's fairly short, right? But to answer Job's question, couldn't the people, through their elected government, decide not to do this ritual anymore? Sure. Now, what if this law was in the United States? What if, for whatever reason, you had this city that was full of a bunch of perverts and sick people who actually want to do this, right? What if no one in the city thought there was anything wrong with this? What if they just washed away their guilty consciences? If the 14th Amendment applied, could a judge sit and say, okay, you're wrong. I'm going to set aside your judgment. Now, some of you say, of course, this is ridiculous. But at the same point, everyone in the town was okay with it. And everyone in the town is okay with this violation of liberty interest. Where do courts get their license to set this law aside? Okay. And this is the fundamental question of substantive due process. This is why it's so controversial. Because rather than a court assessing whether a process is fair or not, right? You know, maybe the process was rigged. Maybe there were 2 pieces of paper with a black spot on it, right? Imagine that they put in several pieces of paper with a black spot. That would mean the process wasn't fair. As a court, you can assess that quite objectively. But with substantive due process, when we're discussing what liberty interest is being infringed upon, there's a lot for the court to do on their own. Do we want courts deciding whether something is just or not? Do we want courts deciding what a liberty interest is or not? Are we comfortable with the court saying that, yes, right to contraceptives or right to abortion or right to sodomy, those are all liberty interests that the state has no power to limit? Who makes that judgment, the elected branches or the unelected judges? And this is a seriously divisive issue that, in my humble opinion, will get only more divisive in about 3 months or so. This is not going anywhere. Okay? So any questions, Hector? Go ahead.
So a court has free license to, I guess, judge whether or not the process was fair. Just the process.
No one disputes. I think everyone will say, well, the process was, you know, say the jury, you know, one of the jurors knew the defendant, right? Easy case, right? Yeah, no one disputes that, even like Scalia. But what people dispute is this act of substance. Everyone know what I mean when I say substance versus procedural, right? You probably say this in Civ Pro maybe. Procedure refers to process. How are things done? Substance means the actual basis of the law, right? That, you know, you can't engage in sodomy, or that you can't procure an abortion, or you can't acquire a contraceptive, right? These are laws of substance, and usually there's sometimes.
So what would Scalia say is what would determine substance? Like how would you frame that?
He doesn't believe it exists.
Okay.
So this, and he actually has reneged on that, but I'll give his position before he did that. But for many years, Judge Robert Bork was a very famous judge who believed in judicial restraint. And what Robert Bork said, I'm going to paraphrase, is that in certain spheres of life, the majority can rule because of the majority. Let me say it again. In certain spheres of society, the majority can rule simply because of the majority, right? He wasn't talking about equal protection here. I think he was more or less on board with equal protection. With respect to violation of rights, for him, that the Roe v. Wade decision was probably one of the greatest travesties in American history. I'm sure if you ask Bork, he's passed away a year or 2 ago. But the fact that you have courts defining this as a liberty interest and telling people that they cannot prohibit this, right, is telling the majority, giving the middle finger to the majority, saying, look, you guys voted for this law, you voted for your legislatures, we know better because we're smart judges. And whether you agree or not with the abortion case, which we'll discuss in a couple classes, the notion of a judge setting aside a law should weigh on you heavily. I know you're all led to believe from the first day of class, oh, Marbury versus Madison, right? Judicial review, that's awesome, right? Courts setting aside all these bad laws. Okay? I want you to think for a moment what actually happens when a court validates a law. That law was voted on by people. Those people send someone to the state capitol. That law was debated. Lots of deals were made, okay? And then at some point later, a court came and said, nah, never mind. What you did didn't count. You know, that'd be like me giving you an exam, right? And then later say, nah, I don't think you deserved it. I'm just going to cancel the exam, right?
So it discounts the republic.
Well, what it does is it sets aside the democratic process. And I hope at some point you all have the chance to work for a judge. And I had this experience my first or second week of clerking. I had this awakening of like, oh my God, right? You know, when you're in law school and you're writing memos and opinions and stuff, you know, it's for fun. But when you're actually sitting there behind the bench, I thought it was fun at least. But when you're actually sitting there behind the bench where the judge is sitting and you're working an opinion that will affect someone's life, liberty, or property, it's a serious burden. It's like, oh my God. This is not like a dumb tweet or Facebook message I just spit off, right? When I write this and says, it is so ordered, something will get done, right? Someone will go to jail for some period of time. Someone's lost a lot of money. Someone may go into bankruptcy, right? The judicial power is real and it's legitimate. And it's so easy in this classroom to just ignore it and say, oh yeah, whatever, right? You know, strike it down, strike that down, and validate this. There's a lot going on there that law school does not even come close to preparing you for. So just when you discuss the idea of substantive due process, think very carefully about how these laws infringe on the democratic process and really have people to determine what laws they have. Now, I'm not saying it's bad. I'm not criticizing it in no way, but it's an awesome power. And to quote Spider-Man, with great power comes great responsibility. And hopefully that is exercised prudently, not like Spider-Man. Yes? Is your hand up?
No.
You sure?
Yeah. You sounded about Spider-Man.
Are you a Superman girl? That's okay. All right. All right. Other questions before I move on? Okay. All right. So that's the general frame. And let's focus for a while on this word liberty. Okay. We're not going to talk much about life or property in this class. We'll discuss property briefly. But let's talk about liberty. And there's a great, oh, Sarah? Ooh, good question. Good question. Give me an example. So I have two answers. So Sarah's question concerns when the Congress tries to remove power from the judiciary. So one of the famous examples is called ex parte Ricardo. It involved jurisdiction stripping. Okay, I don't think I signed. I might have signed this class. I can't remember. It would have been a brief case. And basically, this was after the Civil War, and the court basically said, "Oh yeah, we're going to take away habeas corpus jurisdiction from the courts. Right? We don't like they're setting all these prisoners free." So Congress said, "We're just going to remove this jurisdiction." Okay. When Congress tries to remove jurisdiction from the courts, that's a big deal because that's intended. Courts can only act when they have jurisdiction. The Supreme Court didn't invalidate that law. But what they did say was, as long as we, the Supreme Court, have some sort of appeal path, then it's okay. But this is a very controversial topic, and this is something which you should be very close to. This is from the 1860s. I'm not sure. I'm not sure. All right. Other questions? All right. So let's talk about this word liberty, right? Abraham Lincoln, we're talking about the Civil War. Abraham Lincoln has this great quote, and he says, we all declare for liberty, but in using the same word, we do not all mean the same thing. So again, Abraham Lincoln, he actually said this one, right? We all declare for liberty, but in using the same word, we do not all mean the same thing. So we have a written constitution, and it says that you can't be deprived of liberty. What? What is this word, right? What does liberty mean? I think it depends in large part who you ask. There are about 70 of you in this room. I'm sure if I called every one of you, you'd all give me a different definition of liberty. And there are a couple hundred federal judges in the country. I'm sure if you ask every single one to define liberty, they give you a different definition. I'm sure if you ask the people in 1868 who ratified this amendment what liberty means, and then you ask people in the 1950s during Jim Crow what this means, they give you a different question. And if you ask some people today in 2015 what this word means, they'd also give you a different question, different answer. How do we give meaning to this phrase liberty? And more specifically, how do judges give meaning to this phrase liberty? Christian, what do you think? Which founders? Wrong. Which founders are we talking about here? Be very precise. Who wrote this amendment? What year was the 14th Amendment ratified? Roughly. What time period? When was the 14th Amendment ratified? What? Exactly, 1868. Was James Madison still kicking in 1868? So whose generation, talking about a generation, right? Which generation are we looking at to define the understanding of the 14th Amendment? You just said it. I'm sorry? Which time period would, yes, exactly, right? So this is a common mistake people make. It's like, oh, we have to look at what the framers thought. That's correct for the Constitution that was actually ratified in 1789. That's correct. But we're talking about the 14th Amendment, we have a different time period, right? We have to do originalism at the right time. How would the framing generation, the 1860s, have understood liberty? What was their defining moment? The Civil War. They had just fought a bloody civil war over slavery. They just ratified 13, 14, 15 amendments to eliminate slavery, to provide equal protection, and to give the freedmen the right to vote, right? So we have to ask ourselves, how would a reasonable person in 1868 who read this amendment have understood the word liberty? Okay, that's how an originalist would approach this. Maurice, are we confined, though, to how people in 1868 defined liberty? Why aren't we defined? I'm sorry, why are we not confined by that? Times have changed. Times have changed. Maurice, why is it that when times change, the meaning of the Constitution changes? Where do we get that from? Where do judges, Maurice, get the license to update the meaning of this provision of the Constitution? I know that's what you're led to believe, right? This is what we all understand. And I'm not taking a position on this one or the other. But neither proposition is inherently true, right? There's one idea that says the meaning of this provision is fixed, and we should only understand it how it was understood in 1868, right? This is as Justice Scalia says, it's dead. It's dead. It's not alive. It's dead. Okay, so that's what we call originalism. And then maybe something more living constitutionalism. As Maurice said, times have changed, right? That there's an evolving standard of what liberty means. We look to the context of people today to define liberty. These two positions, my friends, are worlds apart. Worlds apart. And there's almost no agreement on this issue. And I won't take a side here, but I want you to know that there are these wildly different positions. What you should know is that Justice Scalia has lost this one, and that the Supreme Court, largely in the Warren Court in the 1960s, adopted this sort of evolving standard of due process rights. And they started reaching out to rights to contraception, rights to abortion, and then later rights to sodomy, this, that, and the other thing, right? Those are somewhat attenuated from the concerns of the framers who just fought a civil war with slavery, right? The liberty interests of those who fought the Civil War were not about abortion and contraception. That just was not on their radar. But that's how the courts have read it. One point I want to remind you of is this one, privileges or immunities. I discussed this a few weeks ago, but the framers of the 14th Amendment designed the Constitution, designed this provision to protect rights. Anyone remember, Brandon, do you remember in Slaughterhouse, right? This is a case where Louisiana said you can't operate your own slaughterhouse, right? What did the butchers say was their right? What was the right that was being violated? Exactly. The right to earn a living, as you may call it. Okay. It was, and this is not too controversial, at the time of the framing of the 14th Amendment, there was a general sense that you had a liberty interest to choose your own profession. If you wanted to work as a butcher or a baker or a candlestick maker, you could do that. Right? And it was a privileges or immunities clause that was meant to protect that. The Supreme Court just basically read this clause out of the Constitution. Okay? But a funny thing happened, right? A funny thing happened on the way to utopia. Because the Privileges or Immunities Clause was basically cut out of the Constitution, the courts shifted to due process of law. The types of liberty interests that were designed to be protected by the PRI, privileged immunities, were shifted to due process. So this right to earn a living, or it might be called a right to contract, which was one of the privileges or immunities of citizenship, began to be read into the due process clause. So for our purposes today, one of the liberty interests that was understood, whether it's a matter of originalism or evolving standards, was one of economic liberty. Economic liberty. Economic liberty is often called liberty of contract, or if you will, the right to earn an honest living. You can call it whatever you want. It's more or less the same thing. Okay? Yes, sir.
I have a question. After Slaughterhouse and they pretty much struck out privileges or immunities, didn't they then, weren't plaintiffs trying to use equal protection then?
They tried that also, that didn't work either. So strike one was privileged immunities, strike two was equal protection. Then they moved to due process, and that actually kind of worked for a bit. Okay? So to understand this right to economic liberty, I think we need to talk a little bit about the history of where this came from. One of the major prohibitions of Jim Crow was limits on labor. You may recall that after slavery was abolished, at least technically speaking, a number of states enacted laws which basically obligated people to labor. They said that you could only sign a labor contract of 1 year, and if you were not under a labor contract, you were arrested. So various laws were passed, almost primarily against blacks, which made it impossible for them to choose where and when they wanted to work. One of the provisions of the 14th Amendment, privileges and immunities, was meant to prevent this, saying, listen, if you are a free human being, you can choose where you want to work. You can choose the terms under which you want to work. You can choose the wages that you want to earn. You can negotiate, right? There was this notion that the government could not put in arbitrary means of oppressing you and choosing where you want to work. But there was a flip. What was the flip? These initial laws were meant to basically punish blacks, as was often the case. They were trying to limit the professions they could pursue. But that police power evolved. And it wasn't just about punishing people, it was about protecting them. Minimum wage laws, maximum hour laws, health safety laws, union laws, right? The same type of power which the southern states used to limit the working potential of the freedmen. The same police power was then used to put limits on how workers can contract with their employers. All right? It's very difficult to understand this concept because we live in an era of regulation. And virtually every single thing that you do with your employer has more laws and regulations than you could ever understand. I'm sure some of you, when you were reading the Lochner decision, was like, well, what are they, crazy? Of course every profession can be regulated, right? But the 1900s were a very, very, very different time. And I'll provide some background. I'll get to the aftermath. But there was a general notion that as a free person, you can set the terms of your own labor. If you want to work 60 hours a week, which I'm sure all of you will be doing very soon, if you want to work 60 hours a week, then you can work 60 hours a week. If you wanted to take a job that didn't pay as much as whatever wage standard was set, you could take that job that didn't pay much. If you wanted to work in an unsafe coal mine, then that was your decision. You could choose to work in an unsafe coal mine. Okay? So today, what many of you may see as laws meant to help people, right? Guarantee minimum wage, limit the number of hours they can work, require overtime, safe working conditions, right? There was a school of thought in the late 18th, early 19th century, this was an infringement on liberty. That if you were a free human being, you can make your own decisions. The same way that Connie's offended by Michael Bloomberg's law limiting what size soda she can drink, people were offended that you're telling me, what do you mean I can't work more than 60 hours a week? Screw you. I can work as much as I want. You're telling me I can't work in this coal mine? I don't care. I want to make money in a coal mine. Right? So while this was definitely an economic thought, and economists today probably some may agree with it, the question was, is this sense of liberty, does the liberty provision of the 14th Amendment encompass this notion of a right to contract? Right? Does the 14th Amendment put a limit on the state's police power? Does the 14th Amendment prevent states from infringing on the liberty of contract? Right? This is the question for today. Does the 14th Amendment put any limit on the liberty of contract and whether states can infringe it? And what may surprise you, and probably most people in other common law classes, is that 8 justices in the Lochner court answer the question that the 14th Amendment does protect liberty of contract. Okay? 8 justices on the Lochner court all agreed that the Constitution does protect the liberty of contract. This is a position that has never been repudiated, right? That one of the liberty interests we have is freedom of contract. The question at Lochner wasn't whether this right exists. It was, what extent can the state limit it? And those are very distinct issues. We have this right to pursue the choice career, right? I can just be a baker or a butcher, whatever I want to do. The question becomes, how far can the state intrude on that right? How far can the state intrude on this right? Okay, everyone thinks so far. All right, Morgan, what were the facts in Lochner v. New York?
Sorry, I'm not very interesting, but basically there was an act passed that limited the amount of hours that bakers could work inside of their stores, and it was passed with the state's expressed intention to keep them safe in harsh work.
Okay, good. So let's talk about Lochner's Bakery. This is probably the most famous bakery in Supreme Court history. And I have a somewhat of obsession with the case. So I love history, but this case is fascinating. So this is a guy named Joseph Lochner. He was an immigrant baker. Okay, and here are some of the people working in his bakery in Utica, New York. This may not look very clean by today's standards, but by 1905 standards, wasn't bad. Keep that in mind. This is also a better shot of the bakery. I actually discovered this. So before there were even telephone books, there were address books. And I found this from the Upstate New York Historical Society. No one else had discovered this. There was actually an ad for his bakery. And if you look at the sign, it says Lochner's Home Bakery. And if you come to my office, I actually have a huge printout, a blow-up of this, which you can see on hanging on the wall. Okay? So New York passed a law. The law said you cannot work more than 10 hours a day or 60 hours a week in a bakery. That's it. Okay? That's it. You know, Lauren, today, would anyone even second guess whether this type of law was valid? They didn't even think twice about it. Okay. Not so in 1905. Leading up to 1905, when Lochner was decided, there were a string of cases. Among them, Allegheny versus Louisiana, Mugler, and a few others mentioned in the book. I'm sorry, it's a Munn v. Illinois, 1877, Mugler versus Kansas, 1887, and then Allegheny versus Louisiana, 1897. These 3 cases, among others, were decisions by the Supreme Court recognizing that the state can't arbitrarily interfere with this right to contract. Right? So we understand it, Lauren. What is the argument for why why the New York baking law infringes on liberty of contract? What's the argument?
Well, basically they're saying that it's an exercise of
Okay, so the state's saying that this is an exercise of the police power. Why is this an exercise of the police power?
well, they're trying to make, they're going to, they kind of break it up a little bit. They use like the labor law and then they use the health law. And they are arguing that the state can use their police power in order to provide for a safe and healthy environment for the people, the citizens of the state. And so they try to say that's for the benefit of the health of these bakers, and that's how they're arguing they can exercise their police power.
Okay, good. So the state is justifying this under the police power. And we discussed the police power several times, right? This is a protection of health, safety, welfare, and morals. Okay? The state can eliminate stuff, even if it infringes on rights. Okay? So, Jonathan, let me ask you this question. How does a ban on working more than 60 hours a week protect the health and safety of society?
I think they're trying to say that people work too many hours and get too tired. For the person who gets too tired, you won't be able to work effectively, and maybe then say a bakery wouldn't be as clean as it should be.
Okay, good. So, I mean, you just made up a rationale they didn't use, right? Which is fine, though, which is actually very good, right? No, I'm glad you did that. If I ask any of you today, you'll probably say the same thing Jonathan said. Yeah, I guess if you work too much, you may not use clean supplies, and maybe you'll be sloppy, and maybe you'll mix, you won't wash your hands, whatever, right? You'll be tired. That's a valid health rationale, right? But Jonathan, how could the state of New York achieve that goal more narrowly? Let's talk about scrutiny, right? Let's talk about tailoring. How could the city achieve that law more narrowly? Think about it. What do you think, Gabrielle? How could the city improve health standards without restricting hours? Yeah, how could they achieve this goal more directly? You're thinking way too hard. How could the state have made health standards more narrowly? Health safety laws, right? Sanitation laws. You need to wear gloves. You need to wear an apron. You need to wear, a hairnet, right? You need to have the ovens at a certain temperature, right? You need to have health inspectors come by. So in terms of scrutiny, right? Could the state have achieved these health goals without banning hours? Okay. So if we were to apply some sort of scrutiny, some sort of meaningful scrutiny, this law is way too broad. You're basically telling people, even if you want to work more than 60 hours, you can't. We are limiting your liberty of contract. If you want to promote health, pass a law that promotes health. There is nothing in this law, and Jonathan's correct, but there's nothing in this law that directly impacts health. It's only a matter of hours. You can have the dirtiest bakery in New York, but everyone works less than 10 hours a day, and that would have been fine. Okay? George, what's the problem with the analysis I just did? Why do you think New York wasn't happy with what I mean, it took me 30 seconds to dismantle this law. But why do you think New York would not be happy with this type of analysis? No, more fundamentally, right? Why would a state not be happy with this type of judicial analysis? As of course Connie's point before. No, what do you think? What do you think, Pedro?
Well, I was thinking that couldn't the state just argue that?
No, answer my question. Right? Why would this? I have a point. Why would the state not be happy with this type of analysis? Yes. Right. The states have a police power. Right. The states have the police power. The states determine that, in our judgment, the way to promote health safety is by limiting the number of hours. Right? Pedro, use a driver's license example before. If the state wants to limit driver's license to 17-year-olds and not 16-year-olds, it needs to have statistical evidence and rigorous reports and proof of why these people should not be allowed to have licenses. Are they required to?
Under what rational?
For age discrimination, right? Right, the answer is no. Why do the courts not require these types of rigorous analyses for things like, driver's license ages? I don't care about the scrutiny. Why, as a matter of policy, this is important. Why do courts not want to second guess something like that? Anyone? Yeah.
People voted on it.
Yes, democracy. A word which law students do not hear nearly enough. Democracy, right? People voted for these members of the state house, right? They voted for them, and they passed this law. People voted for the New York legislature, who voted for this hour law, right? Why, Yasmin? Why do in some cases we apply this sort of heightened scrutiny? What's the rationale there? But what makes these classes suspect, right? Why are we so suspicious about race? Yes, okay, this is the important part. There are certain aspects of our society where we're very skeptical of government action involving race or religion. That when the government's infringing these rights, they may have bad motives. So we look more closely, right? Elliot, when we're talking about the right to contract, this is going to be a trick question. Does a state have a bad motive in limiting hour laws? Okay, you're wrong, okay? But we presume they don't. And this is a point which was raised in Justice Harlan's dissent. When a state enacts a law which they say is involving health and safety, we do not question their good faith. We do not question their good faith. I didn't mean to say you're wrong, but there's history there, right? Because there's not this history of discrimination against races, right? Because we don't have this long-ranging history of the right to earn a living being oppressed, the courts are not skeptical here. Everyone get that? That the Lochner court, right? The Lochner court found these rights to be very important. But what came afterwards is basically the recognition that no, these rights aren't important. We'll get to that in a few minutes, but I want to give you the history, right? Does anyone ever hear of the concept of the Baptists and the bootleggers? Explain it. So, right, who's in favor of prohibition? Pooch. So, there's this funny concept called Baptists and bootleggers, right? So, during Prohibition, who were the biggest supporters of banning alcohol? Well, the Baptists, right? They were morally indignant. They were opposed to drinking any alcohol, okay? And the bootleggers, right? These are people who are going to profit off of this law. So with respect to Lochner, who are the Baptists and who are the bootleggers, right? What do you think, Amanda? In Lochner, right, with this health safety law, who are the Baptists and who are the bootleggers? Who? Okay, now this is the important question, right? So there were Baptists in this case, right? There were people who actually wanted to promote health and safety. They exist, and these are good people, right? It's like we need to get working conditions safer. Joseph Lochner had a small immigrant bakery. He had a couple employees, not many, right? These were almost all German immigrants. In order for his workers to compete against the more established bakers, they had to do what most immigrants do, which is work insane hours, right? The way that immigrants can compete against more entrenched people with better equipment and more facilities is by working their butts off. This is nothing new. This has been so old as the world. Who do you think supported the 60-hour law? The bakers. Ding, ding, ding. This law was supported by the unionized bakers who had every interest in putting out of business these small upstart immigrants. And there was some xenophobia there as well, I'll add. Right? This is a classic Baptist and bootlegger scenario where ostensibly this is a health and safety measure, which doesn't actually mention health or safety, only mentions hours, but it's supported by these various groups who want to punish these upstart bakers. Because if they can only work 60 hours a week, they won't have enough bread. And that means more bread from our store. Ding, ding, ding. So this is a type of analysis which the majority opinion by Justice Peckham was not ignorant to, right? He actually makes this point towards the end of his opinion where he says, listen, I think it's like the second to last paragraph if you turn to it in your book. I'm only trying to find my notes. He says, quote, I love this quote, right? So Justice Peckham, and by the way, my friend, and he was my ConLaw professor, George Mason, David Bernstein, wrote a book, which I gave you an excerpt of, called Rehabilitating Lochner. It's a controversial book. I'll explain why in a moment. But the cover art is Justice Peckham knocking out Justice Holmes for the Lochner. But he says, listen, it is impossible for us to shut our eyes to the fact that many of the laws of this character, while passed under what is claimed to be the police power, are in reality passed from other motives. Right? So in other words, the majority opinion wasn't, they weren't being stupid, right? They said, listen, we know what's going on here. This is not a health and safety law, right? If you tell us that you can only work 10 hours a day in a coal mine, okay, fine. But 10 hours a day in a baker, are bakeries dangerous? Are they any more dangerous than being a lawyer or a banker or a tinsmith? Probably. But the court said this is not about health and safety. So I'm going to get the majority opinion. And I won't go through the reasoning too much because the case is long since it's repudiated. But the general gist is the court saying, we know what's going on here. We understand what's going on here. And we are not in a position to second guess. I'm sorry. And we are in a position to second guess the legislature. Right? Baking is not an inherently dangerous profession. Why are you laughing? No, I'm serious. It's a good question. Why was that funny? What do you mean common sense? Where do we get this common sense from? Not a dangerous. It's not like coal mine. Right. What, Lauren?
Anyone does it. People do the same thing at home all the time.
So what's going on here, and that's why I didn't mean to sound common, but what's going on here is that they're using their common sense. They are substituting their common sense for the common sense of the New York legislature. Everyone see that? The New York legislature said, wow, this is a dangerous profession and we need to regulate it. Plowman's like, these idiots, right? Justice Plowman's like, what are they talking about? This is, we're going to get some flour in your hair? I mean, what's the big problem, right? Get some dough in your fingernails, you can't get it out. I mean, what's going to be the problem? Look at these guys. Look how happy they look, right? And they look, liberty, right? Can't these guys decide if they want to work more than 60 hours a week? Who is the state to say that we are going to arbitrarily interfere with this right? Okay? And that is what the majority decided. The majority by Justice Peckham said, unless, that this law is arbitrary, it infringes on the liberty interest protected by the 14th Amendment, this liberty of contract. It tells these guys that any health or safety rationale, you can't work. You are an idiot. I don't care what you think. Because you want to work 60 hours a week, you're wrong. I, the government, know better. Peckham says, no go. Everyone get the majority opinion. Okay, Alana, let's turn to the dissent, the primary dissent from my man, Justice Harlan, right? This is the same Harlan who dissented in Plessy versus Ferguson, the same Harlan who dissented in the civil rights cases, and the same Harlan of the opinions of the other racial cases. He was a very significant justice. Alana, what is Justice Harlan's position? You have it? Renee, what is Justice Harlan's position? Yes. Okay. So to start, Renee, does Justice Harlan agree that there is this liberty of contract, that it exists?
Somewhat.
Good. Okay. So he doesn't dispute, and this is interesting. So 8 justices in this case, they don't dispute that this liberty of contract exists. Make sure you remember that, because people don't characterize opinion well. But what does Harlan say about that one, Renee?
I guess that they do have the right to contract, but it can be like restrained.
Okay, very good. So Harlan flips the equation, right? The majority opinion by Justice Peckham involves the courts second-guessing the legislature, saying, wait a minute. This isn't really about health, right? This is some sort of protectionist law meant to punish small bakers, which it was, right? This was meant to punish the small bakers. In contrast, Harlan's like, no, that's not how this works here, right? The burden is not on the state to prove this law is legitimate. The burden is on the challenger. The burden is on Lochner to prove that this law is void. This shifting of the burden changes everything. Because again, I said this over and over again, once you have the burden, that means you're probably going to lose. When you have the burden of proof, you're probably going to lose. Raise your hand or no? Yeah. So here's the test that Harlan gives, which is probably closer to where the law stands today. Okay? He says, a law should never be invalidated, quote, unless it be beyond question, plainly and palpably in excess of legislative power. I'll read it again. A law should never be invalidated unless it be beyond question, plainly and palpably in excess of legislative power. In other words, unless this law is really, really, really terrible, it should be upheld. If the court can find a way to read it, in a way to uphold it, they should. Hello, John Roberts, right? Sound familiar? Hello, John Roberts and Obamacare. If there's a way to read the law, to uphold it, the court should do so. What does Harlan say? If the law is really that bad, the democratic process should fix it. Hot damn democracy, right? If the law is really this egregious, democratic process should fix it. Okay. Jennifer, will the democratic process fix this law? Why?
For it to even get to the court, somebody has to be on.
No. Will the state legislature repeal this law?
Oh, no.
Who does it benefit?
In this case,
Yes, the entrenched bakers who support the legislature, they back this law. Who opposes it? These poor immigrants, right? So it's probably not true that the democratic process will fix it. But Harlan says, you know what? If this law is so bad, let democracy fix it. I think that's probably the correct frame for a judge to think, although in reality, it's probably not true. Connie? Oh, okay. Okay. So let me write out Harlan's framework, okay? And this is from Justice Harlan in a case. He says, if the end which the legislature seeks to accomplish be one to which its power extends, and if the means employed to that end, although not the wisest or best, are yet not plainly and palpably unauthorized by law, then the court cannot interfere. And I write this out in its whole because I want to discuss it for a moment. If the end which the legislature seeks to accomplish be one to which its power extends, and if the means employed to the end, although not the wisest or best, are yet not plainly and palpably unauthorized by law, then the court cannot interfere. Okay? This is means-end scrutiny. Right? This is the exact framework we're using before. Here are ends. If the end which the legislature seeks to accomplish be one to which its power extends, this is basically one of legitimacy, right? Like on a rational basis, is this a legitimate end? Okay. And if the means you're employed, although not the wisest or best, are not yet plainly unauthorized by the law, okay, these are the means of rationality. Is it rational to limit hours to 60 hours a week for public safety? Yeah. Okay. Is promoting public safety and food safety legitimate? Yeah. Okay. So we have these two concepts. We have these two concepts in Harlan's test, which is effectively what's become the rule. Not exactly, but this is a very good formulation of it. So I love Harlan. Okay. So long as the ends are legitimate and if the means to get there are rational, even something that infringes on your liberty interest will be upheld. Courts should not get involved in interfering with the democratic process in this way, unless the law is so horrible that it can't be invalidated. Okay. And that is the exact rub of the issue. How does a court decide what is horrible? How does the court decide what a liberty interest is, right? As soon as you acknowledge, and I said 8 justices did so, as soon as you acknowledge that there is a liberty of contract, then judges have to make this decision. Taking the opposite perspective, in dissent, all by his lonesome self with his mustache, was good old Ollie, right? Oliver Wendell Holmes. And this is probably the most famous dissent of all time or close to it. I think undeservedly so, but it's still very famous. Okay? What does Holmes say in his dissent? Again, all by himself. There is no liberty of contract. He says maybe as an economic theory, right? Maybe as an economic theory, it makes sense to protect this liberty of contract. But he says the Constitution has no such provision. That the Liberty Clause of the 14th Amendment doesn't include this at all. The most famous quote, which is wrong from his opinion, is the 14th Amendment does not enact Mr. Herbert Spencer's social status. Okay, who is Herbert Spencer? He was a prominent social Darwinist. And if those of you who studied it, social Darwinism said you need to have survival of the fittest, right? If poor people don't keep up, let them die off. Okay? So Holmes is saying that we should not be incorporating this type of laissez-faire economic theory, the social Darwinist philosophy, into the 14th Amendment. That the state's police power is so broad and that there is no right of contract in the Constitution. Oliver Wendell Holmes once said, and I love this quote from him, if my fellow citizens want to go to hell, I'll help them. It's my job. He was a firm believer in majoritarianism, that if the majority wants to do something, then they could do it. It was very much like Robert Bork, who said, in wide areas of life, majorities are entitled to rule if they wish, simply because they are majorities. Okay. Holmes's position was that there is no liberty of contract. This is all fake. It's a myth. And that courts should not be second-guessing the legislature. If the legislature wants to protect health and safety in this way, that is their prerogative. Okay, the dissent is very witty and very pithy, but if you notice, no one joined it. A lot of people celebrated, but that wasn't even the primary dissent in the case. Okay. So any questions on Harlan's dissent or Holmes's dissent? Yes, ma'am. I'm going to say that in a minute. Any other questions on the Harlan or Holmes dissent? Okay, so why is Holmes celebrated as this, this scion of this constitutional law? Okay, because something called the progressive era. Okay, the early 1900s, in the United States, were a time of social experimentation, bold social experimentation, to use FDR's word, where long-standing values of liberty of contract and property rights ran headlong into progressive desires to reform the state. Health laws, safety laws, antitrust laws, right? All these various progressive goals, which were meant to make the state better through government control, ran directly into this notion that I have a liberty of contract. The state cannot interfere with my right to work, my right to own property, etc. Okay? The biggest demon, the biggest boogeyman, became Lochner. Teddy Roosevelt, who was the governor of New York, railed against his decision. He said this was terrible. If the state wants to ban bakers working too much, that's their prerogative. And even to this day, not in my classroom, but in most classrooms, Lochner will be held up as one of the worst cases in the Supreme Court. I am not joking. You will see Korematsu, Dred Scott, and Lochner in the same sentence. Okay? Why is it that a case telling bakers they can't work more than 60 hours is in the same level as demeaning people to, not even human, or throwing Japanese people in the concentration camps? Because it gets in the way of progressive goals. And that's a little editorializing on my part, which I try not to do, but I think here it's actually apt. This is an opinion that would stand in the way of the New Deal and the modern administrative state. That whenever anyone wants to criticize something that might chip away at our administrative or welfare state, they say, Lochner, Lochner. It's almost like, Godwin's law. In any debate, when someone mentions Hitler, the debate's over. Okay, in any debate, when someone mentions Lochner, you say, okay, this debate's over. Because it's not a substantive argument anymore. It doesn't mean anything. It's taken on a life of its own. The actual case itself was controversial for sure, but consistent with how the case law had evolved at that time. And I promise you, if you ask go ask your fellow ConLaw students that Lochner will get a very different story. But this is my perspective. I was actually David's student, so I suppose I'm part and parcel of this rehabilitation. But the point you have to remember is the New Deal ran into a lot of these problems. We've discussed this a few times before, that a number of the early New Deal laws, which were meant to regulate hours and wage laws, were at odds with Lochnerism, right? And the Supreme Court somewhat consistently, somewhat inconsistently applied these principles to invalidate many state and federal laws that infringe on liberty of contract. Okay? Roosevelt could have none of that. The democracy had just elected him in a wide-ranging election. The Congress supported his beliefs and his policies. Who were the courts to second-guess their economic theories? Who are the courts to second-guess whether Social Security was a good idea, whether the National Recovery Act was a good idea, whether state minimum wage laws were good ideas, right? Could the courts apply this doctrine of liberty of contract in a manner to invalidate them? This is why Lochner is viewed as so evil, right? Because it allowed the courts to second-guess the elected branches on matters of the regulatory state. It allowed the courts to substitute their wisdom over what the best economic policy is over the elected branches. It allowed the courts to say, you know what? We don't think minimum wage laws are a good idea. We don't think they're a good idea, right? Let the poor person negotiate and argue for his wages, right? Let the impoverished person decide, yeah, I'm going to decide to work in a coal mine. I don't care about that. These were worldviews entirely at odds. Could the poorest of the poor make these rational decisions about what a valid contract is, right? Meaningfully, could a poor person say, you know what? I don't want 15 cents an hour, I want 16 cents an hour, and I'm not going to work unless you give me that. Well, they tell them to go and leave, right? Was this liberty of contract an illusion? Was it real? Was it even worth protecting? So this was the progressive mentality. We need to safeguard the little guy. We need to protect the little guy who can't look for himself. These poor bakers are being forced to work 60 hours. We need to protect them. Liberty of contract stands as an obstacle to that. So there were a number of cases, which I'm going to go through a little bit quickly, which are mentioned in your book. One was a Mueller versus Oregon, right? This law prohibited women from working more than 10 hours a day. It prohibited women from working more than 10 hours a day. Why? Well, some may say, well, this was to protect women. From what? Women were viewed as inferior. And I'm not saying this lightly. There actually were studies about how if women work too much, their uteruses will fall out. I'm not joking. You can Google this. I don't make stuff up. I wish I could. There were actually reports in the so-called Brandeis brief. William Brandeis, famous Supreme Court justice, submitted a brief saying that if women work too much, their uteruses will fall out. I'm not joking, right? Talk about a war on uteruses, right? So Oregon passed a law banning women from working too much. And the court upheld this, the fairer sex. So I don't know. Women, is that a victory or not? You can judge that for yourself, right? Another case called Atkins versus Children's Hospital, 1923, the District of Columbia, right? This struck down a minimum wage law for women. And the court said, you know what? Women are just as equal as men, and they can negotiate whatever rates they want. Was this true or not? You guys can debate this, but the court said liberty of contract. So everything was moving along in a somewhat erratic fashion. Some of these economic laws were upheld, some were being invalidated. You often read about the so-called Lochner era, this Lochner era where the court struck down everything. That's simply false, right? The court said like 200 laws were invalidated and thousands were upheld. It's, what's your denominator? So a lot of laws were invalidated, but many were. But the Lochner era came to a decisive end in 1936 and 1937, a period which we focused on very heavily, with a case called West Coast Hotel versus Parrish. Okay, I think I have a picture of it somewhere. The West Coast Hotel. It's in Wenatchee, Washington. Okay, oh, there it is. Yeah, that's the West Coast Hotel v. Parrish. Ignore the modern mail truck in front of it. It existed back then. So you had a law which imposed a minimum wage for women. Mind you, the court had just struck down a minimum wage law about 13 years earlier in DC. This was a Washington law. The initial vote for this case was 5-4 to invalidate the minimum wage law. FDR announced his court packing plan. There was a switch in time that saved time. The vote of Justice Roberts. Yes, indeed, it was Justice Roberts who changed his vote. It's a pattern. Don't name your son Robert, right? It was a pattern where where Justice Roberts changed his vote to uphold the Washington law. After this case, almost all the 5-4 decisions started going the other way, and liberty of contract faded to oblivion. Okay, this was the turning point, and I encourage you to read, if you like, Justice Sutherland's dissent. And this goes to the point before Maurice. Justice Sutherland said the meaning of the Constitution is fixed, and it only changes by amendments. This is one of the earliest articulations of what we might today call originalism. After West Coast Hotel v. Parrish, there were a string of cases discussed in your book, where one after another, the court basically said there is no liberty of contract. Okay? And what ended up happening was that what we now call rational basis review, right? Rational basis review was now applied to economic liberty. So in the same sense that with equal protection, we classify people based on race or religion, we actually classify rights. We have categories of rights. Okay? We actually have categories of rights. We have what are called fundamental rights and non-fundamental rights. Okay? Economic liberty was deemed not a fundamental right. Okay? Therefore, we give it rational basis. Same way with equal protection that we classify people based on their race or religion or these different classifications. We group together rights. We have fundamental rights and non-fundamental rights. After 1937, economic liberty, this right to contract, became a non-fundamental right, and then we apply effectively what's a rational basis review. But this rational basis isn't the same rational basis we use for equal protection, right? It's actually even worse, if you can imagine. So there are two cases, and I realize I'm running short on time, but I'll mention this briefly. There are two cases in the notes. First one is called Williamson v. Lee Optical. Williamson v. Lee Optical. Second one's called Ferguson versus Scrupa. I discussed the Lee Optical case last week. This was a case where the state said that only doctors could fit lenses for glasses, right? You have to have a medical license to fit lenses. Is there any reason why you need to have a medical license to fit glasses and a lens? Of course not. This was a protectionist law. This was meant to protect the doctors. But the court in this case said, you know what? This economic liberty, fit, right? We're not going to second guess the judgments of the states. We will make up a rationale for why this law may be necessary. Because economic liberty is so unimportant, because economic liberty is so trivial, it should not get in the way of the state's police power. The courts will no longer use the 14th Amendment to invalidate laws that infringe on liberty of contract. So after Williamson v. Lee Optical, in 1955, economic liberty is on life support. It exists in theory only, and the court has shown almost no reason why they want to protect it. And lurking in the background is Lochner. And whenever anyone even raises the idea of protecting economic liberty, they scream, Lochner, right? You know, like Rosebud, right? It's Lochner. It's there. It's always hiding in the background. It's like this creeping ghoul that will come and snatch you at night for not paying attention. That's why it's so hated today. Because any law that impedes various progressive legislation, health safety laws, Lochner, right? All right. I'm leaving, like Taylor, I'm going to leave this one blank for now. Blank spaces, right? I'm leaving that blank for now. We'll discuss in a future class what the fundamental rights are. But for now, know that the economic rights are not fundamental. Any questions? Have a wonderful day. No class on Thursday. And today at 4 p.m., in the 6th floor library, there's a session by the Federal Society on the Texas Constitution. Professor Rhodes is speaking. I encourage you to go. Okay? And no class on Thursday. 4 today. Have a great day, everyone.